Finally, there are rules that specify whether a dispute should be heard in the state or the federal court system. Superscript 7, which reads the rules for resolving whether a state or federal law should apply in a particular dispute are complex and themselves constitute a special course in law called conflicts of law. Back to the text. This is often a matter of great strategic significance in an attorney's handling of a case. The general rules for deciding jurisdiction are relatively straightforward. State courts have jurisdiction in disputes involving state statutes or in civil actions between the residents of that state or in states arising under federal law when Congress has not given exclusive jurisdiction to the federal courts. The jurisdiction of the federal court is defined by Congress through the powers assigned in the Constitution. That jurisdiction is limited to three principal areas. One, federal questions. That is, those matters arising under the United States Constitution or federal laws or treaties, superscript 8, which reads there used to be a minimum dollar amount in controversy, $10,000 before a case could be a federal case, even if it was a federal question. That minimum no longer applies to matters arising under federal law. Back to the text. 2. Cases to which the United States is a party. Typically, these are criminal cases under federal statute. 3. Diversity cases. Repeating, diversity cases. Any civil dispute currently involving more than $75,000 between the citizens of different states. In the late 18th century, Congress allowed these disputes to be removed from state to federal courts because it felt that state loyalties were so strong that the citizen of another state might lose in a state court regardless of the merits of his or her case simply because he or she was a foreigner. Superscript 9, which reads in 2007, Congress raised the minimum amount in controversy in diversity cases in order to alter the caseload of the federal courts. Clearly, the greater amount in controversy required, the fewer the number of diversity cases that will be eligible for resolution by the federal courts. Back to the text. In the event that a federal district court hears a diversity dispute not involving a federal question, the court will generally apply the law of the state in which it sits. Today, diversity of citizenship is no longer as compelling a reason for the federal courts to assume jurisdiction as it was 200 years ago. Indeed, former Chief Justice Burger urged Congress to ease the caseload of the federal judiciary by entirely removing the diversity cases from federal jurisdiction, superscript 10, which reads but there is still an argument for maintaining federal jurisdiction in diversity cases, where the benefits of a decision may accrue to the people in one state and the cost fall on the people of another state. Back to the text. As to the selection and tenure of judges, there are two broad practices. For the federal bench, the rule is appointment by the president with the advice and consent of the Senate for life tenure with removal only by impeachment by the House of Representatives and conviction by the Senate. For state judges in a majority of the states, the rule is election to the bench and limited tenure. For the remainder of the states, the state judiciary is nominated by the executive branch and approved by the legislature for varying but fixed terms.